record in the matter of the people of the state of Michigan versus Gennaro Edwards, file number 23-00747, council appearance.
Brian Ring on behalf of the people.
I had somebody represent me.
I'm sorry?
I didn't understand how somebody represent me and I'm representing myself. And I can't see myself on Zoom.
Nobody said they were representing you.
Oh, I thought that's what you did.
He said he was here on behalf of the people.
Oh, okay. My fault. I'm sorry, Your Honor.
This dude's ears aren't even working properly, yet he's about to sit up here and attempt to represent himself. And it seems like he's a bit under the influence. This should be good.
Okay. You wish to represent yourself, sir?
Yes, ma'am.
Okay. And why
I can't see myself on the screen.
Okay. Are you under the influence of anything at this time?
Yes.
No, ma'am.
Okay. I don't know why you can't see yourself on the screen.
I could just hear me and see you.
Maybe it's because he's a sovereign citizen vampire.
Okay.
But that's okay. That's okay. That's okay.
Okay. Okay. So you understand, sir, that you do have the right to have court-appointed counsel represented at the expense of the public if you cannot afford to hire an attorney?
Yes.
Okay. And you wish to waive that, you say?
Yes, ma'am.
You know what?
One more
Mr. Edwards, you need to appear in
person.
You need to appear in person today, okay?
How was I supposed to appear in person? I live in East Point, Michigan. That's down there by Detroit. I've been served a summons felony and not a complaint felony. I don't know what's going on, ma'am, and I want to avert the jurisdiction and read my warrant into record.
Okay.
I don't know what's going on, ma'am, and I understand this Zoom is illegal according to Tyler versus Illinois.
What? Wow. Now that was a new one. Zoom court hearings are against the law. Maybe this is why the judge has abruptly stated that she wants you to appear in person, because you're sitting up here talking a bunch of nonsense and you are coming off as if you are under the influence of something.
48 for US 400. I know it is. So I know I have to report, but you're going to have to give me some time because I don't have transportation.
Okay, when are you going to get here?
You're going to have to at least give me a month. You're going to have to leave.
No, you're not getting a month. You got a court date on the 13th.
I can't make it. I can't make it.
Okay, well, then you'll get a warrant, okay?
I'm asking the court.
If you don't appear on the 13th, you'll have a warrant for your arrest. We're not giving you a month to show up to court.
This dude is out of his mind. The judge is trying to get this man down to the court house that very same day, and he's talking about he needs a month. That right there, that's funny.
Ma'am, I'm asking the court.
Do you have any questions at this time?
Yes.
What's your question, sir? I'm happy to answer them, but what I won't do is go back and forth with you about nonsense, okay?
Okay, yes. All right. I have a corn warrant. May I read it into record?
I'm sorry, you have what?
I have a warrant. I have a warrant. I have a warrant.
You have a cornrow warranto.
What are you talking about? Can I ask what it is?
It's QUO warranto, and I have lack of jurisdiction and a motion to dismiss.
Okay, gotcha. Yeah, you need to file that with the court and serve it on the prosecutor. We're not reading that on the record today, okay?
We can't read it. All right. Well, since
No,
we
you
can't
need to
read it
file
on
it
the
with the
record,
court. You need to do an appropriate filing, and then you serve the prosecutor, okay?
I will, ma'am. But I have one more other thing. Since this is probable cause, can you at least let me know what my charges is and who is lodging the charges against me?
Yeah, did you appear for your arraignment on March 8th?
Yes, I did, ma'am. And they put me on a
Okay,
personal
were you advised at
bond.
the time of what you were being charged with?
She said something about larceny, but she didn't say from who.
That's exactly what you're being charged with, a larceny.
Yeah, right, but she didn't say from who.
You're being charged by the people of the state of Michigan for count 1 on or about August 19, 2022 through August 20th, 2022 at the area of 4600 Collins Road, City of Lansing, Ingham County, State of Michigan, for allegedly committing the act in count 1 of larceny, $1,000 or more, but less than $20,000. It alleges that you did commit the offense of larceny by stealing money that belonged to a Avonshire. The value of the property stolen $1,000 or more, but less than $20,000. This was contrary to Michigan Compiled Law 750.356.3a. That's a felony. Maximum penalty 5 years and/or $10,000 in fines, or 3 times the value of the stolen property, whichever is greater. To impose a fine of 3 times the value, the defendant must admit the amount, or it must be determined by a trier of fact at trial. There's an habitual offender, 4th offense notice. So that would enhance the maximum penalty on this. It says take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies, and that on or about May 11, 2016, he was convicted of the offense of failure to return rented property, $1,000 to $20,000, in violation of MCL 750.36583A in the 16th Circuit Court of Macomb County. And that on or about March 7th, 1997, he was convicted of the offense of delivering, manufacturing less than 50 grams in violation of MCL 333.74012A4 in the 4th Circuit Court of Jackson County. And that on or about March 7th, 1997, he was convicted of the offense of carrying a concealed weapon in violation of MCL 750.224 in the 4th Circuit Court of Jackson County. And that on or about March 7th, 1997, he was convicted of the offense of felon in possession in violation of MCL 750.224F in the 4th Circuit Court of Jackson County. And that on or about February 5th, 1993, he was convicted of delivering, manufacturing less than 50 grams in violation of MCL 333.7401224A in the 31st Circuit Court of St. Clair County. And that on or about March 14th, 1991, he was convicted of the offense of delivering and manufacturing less than 50 grams in violation of MCL 333.7401224A in the 4th Circuit of Jackson County. And that on or about August 5th, 1991, he was convicted of the offense of delivering, manufacturing less than 50 grams and contrary to MCL 333.7401224A in the 31st Circuit Court, St. Clair. And that therefore, the penalties are a maximum of life if the primary offense was 5 years or more.
So not only is this drunk sovereign citizen a thief, he is a career criminal. Judge, just lock him up.
I just can't get my behavior under control.
Or 15 years or less if the primary offense has a penalty of under 5 years. This is, again, a larceny with the maximum penalty of 5 years. So you are facing life as a maximum penalty. I ask you again, do you want court-appointed counsel?
Okay, ma'am. I want to interject that the MCR 404B1 said you have to show conformity to the habitual, and there's no conformity, and is over 10
This
years
is a probable
old.
cause conference. We don't have to
It's
show any
over 10 years
conformity at a
old, man.
probable cause conference. So this is what we're gonna do. We're gonna see you in person next week, okay, sir?
I can't make it now.
Well, if you don't make it, guess what's gonna happen? A bench warrant will issue. You go ahead and have a good day. I got other cases to handle.
Sorry. Can I call up my witness for next week, or do you want to?
You absolutely can.
Thank you.
Bye.